time to get started. My name is Bruce Hammer, and today we're going to talk about, mostly we're going to talk about one subject, which is fair housing. And then in the end, we're going to throw in a little discussion on antitrust, federal antitrust, and what those laws mean. So hopefully this week, we will not have anybody hacking into our Zoom meeting and blasting us with stuff we don't need to hear. For those of you who weren't here last Tuesday, we had an invader who hacked into our class, and we exited him pretty quickly. But anyway, fair housing. Geez, we hear about fair housing all the time. And for most of us, it's pretty common sense stuff. Fair housing laws come to us from our history in the country, and that history, if you look at all the different laws that have been passed, the fair housing laws are a result of going back to 1863 with the Emancipation Proclamation. You've got the 13th Amendment to the Constitution in 1865, which basically freed the slaves. You've got the Civil Rights Acts of 1866 and 1870. The most important addition overall, which carried a lot of what fell into the various fair housing laws, is the 14th Amendment to the United States Constitution, which deals with substantive due process. And under the moniker of substantive due process, you have personal freedoms, personal liberties. You have, that's where all of the stuff with, same-sex marriage came out of, the right to marry, the right to raise your family as you see fit, the right to travel wherever you want to in the country. All of those types of opportunities came in part out of the 14th Amendment of the U.S. Constitution. You also have the 15th Amendment, which falls into fair housing issues. Here in California, in 1959, we passed the Unruh Civil Rights Act, which was huge here. In 1959, we also passed the California Fair Employment and Housing Act. And in 1968, the federal government passed the Federal Fair Housing Act. So all of this together, and the thing that's interesting is if you look at each of these various laws and constitutional rulings that have come out, and so you got federal law, statutory law, you've got federal court cases, you've got constitutional law cases, you've got within the state of California, we've got California Constitution coming into play. We've got California statutory law, and we have various case law in California. You put them all together, and although a particular category of person may not be covered under one law, I can guarantee you it'll be covered under another law. So when we talk about fair housing violations, you have to understand first that all fair housing violations are, they spring from a violation of the rights of a particular category of person. It sounds like a really mechanical way of explaining it, but all of the laws divide the various people that can be victims into various categories. And so, you might have religious categories. You might have race categories, the obvious ones. You might have sex categories, male versus female. All of these are defined as categories. And I guarantee you that whoever is involved claiming discrimination, they will be a person that will fall into one of those categories. So the best way to understand fair housing is treat everybody equally. And I will tell you too, and I've said this in my other classes, real estate agents, at least in my view, they don't wake up in the morning and say, who can I discriminate against today? That doesn't happen. Where they usually get into trouble is they do something without thinking. They have a lapse in their thought process, or it's a lapse in their education that causes them to have a lapse in their thought process. They don't intentionally try to discriminate, at least the realtors that I've known. Now, that said, if you're not careful, you can easily accidentally just, get into a situation where you discriminate against somebody. And as I go through some of this stuff, you'll understand just how easy that can happen. Unintentionally, but easy. So, first of all, as a whole, I will tell you that the Fair Housing Acts, ACTS, they set forth the minimum standards for preventing discrimination in housing. The U.S. Department of Housing and Urban Development, aka HUD, they administer federal fair housing laws. The rules that they develop further define and interpret the provisions that are contained in those laws. Then local governments can enact fair housing laws that are even more strict than what was established under the federal government. They can't be less restrictive, but they can be more restrictive. And here in California, that has definitely been the case. California's fair housing laws are extraordinarily strict, much more so than the federal government's. As a supervising broker, we have to ensure that all of our licensees comply with, all of the anti-discrimination type laws. All right, so if you look at the federal fair housing law, like I said, you have various agencies that come up with these. Ironically, under the federal fair housing law, there's only actually 7 federally protected classes, and that would be race, color, national origin, religion, sex, handicapped, and familial status. So what does that mean? You can't refuse to rent or sell housing. You can't refuse to negotiate for housing. You can't make housing unavailable if it is otherwise available. You can't deny a dwelling. If you're in lending, you can't process an application more slowly in order to avoid a sale, rental, or financing of a property. You can't set different terms, conditions, or privileges for the sale or rental of a dwelling. You can't falsely deny that housing is available for touring, sale, or rental. You can't channel or steer a particular person towards or away from a property. And we'll talk a little bit more about channeling or steering in just a few minutes. You can't persuade owners to sell or rent their property by inciting fear in them. That's known as blockbusting. And I'll give you a little story about that later too. You can't deny a person access or membership to a facility or a service, such as the MLS, that's related to the sale or rental of housing. You can't refuse to make a mortgage loan if they are otherwise qualified. You can't refuse to provide information about loans. See, and these are the types of things where if you're a real estate licensee and you're dealing in loans, these are the kind of things where maybe you're not intending a discriminatory practice, because maybe you believe the person's not qualified, so you say, well, why even bother giving them information about a loan? It's a waste of your time. Well, under the fair housing laws, what you believe subjectively is irrelevant. You still would need to provide them with information regarding the loans. You can't impose different terms or conditions on a loan like different interest rates, points, or fees. Discrimination in appraisals has become a big deal. And in fact, as you know, there is now a Fair Appraisal Act document where we disclose to a client, buyer or seller, the various problems with discriminatory appraisals. Advertising, you can't advertise any statement that indicates a limitation or preference based on any of those 7 protected classes. Everybody clear on all this stuff so far? Okay. And on the advertising, any type of advertisement that that includes language that would indicate a preference or a limitation on the type of people to which a property is available to buy or rent is considered discriminatory. Any type of advertising that has a discriminatory impact is also prohibited. And that is now something that if you're going to renew your real estate license, they're going to test you on that stuff. They've really expanded the licensing exam as it pertains to fair housing for the next renewals that you're going to be doing. Let's see. NHUD has developed rules and regulations to assist newspapers in how they process advertising. So presumably, even if you wanted to run an ad in a paper or some sort of a magazine and it had discriminatory comments, presumably the newspaper would be aware of certain things they can or can't say in those ads. But here's an example of some of HUD's advertising guidelines that they send out to various newspapers and magazines. You can't reference race, color, national origin. No discriminatory limitation or preference can be stated in the ad. Religion, can't have a religious preference or limitation. You can't express that at all. Sex, no explicit preference based on sex. You can't run an ad if you're renting a property. You can't run an ad that says, I want a female roommate or I want a male roommate. That's considered a violation of fair housing. If you're representing a seller and the seller for some crazy reason had a preference for a male or a female buyer, you can't advertise something like that, whether in a magazine or in the MLS. Actually, MLS would probably flag you for it to begin with anyway. Handicap, you can't have an exclusion or limitation based on a handicapped, on somebody being handicapped. Photographs of people. This is where it really gets interesting. You have magazines and stuff, and real estate companies might advertise, or real estate team might advertise. If you want to completely avoid fair housing type situations, you better make sure you have a diverse representation that you're showing in these photos. Otherwise, it could be interpreted as a potential fair housing violation. They've come out with a list of unacceptable words and phrases, and a couple of these you'll be a little shocked about. Acceptable words, we'll go through those first. Close to downtown, den, near, such as near UCLA. No smoking or drinking, that's fine. Number of bedrooms is fine. One apartment, play area, privacy, private setting, school district, schools, secluded, security provided, senior discount, and seniors, if the place is certified by HUD as senior housing. You can talk about square feet, townhouses, traditional style of home, and view. Now here's where it gets interesting. Here are the unacceptable words and phrases. Some of these might be a little surprising to you. Adult, can't say adult building, adult park, etc. Although you can say active adult community if it's like a 55 and older community approved by HUD. Adults only, bachelor pad, black, blind, board approval, company, couple, couples preferred, couples only, things like that. You can't say crippled, deaf, drinkers, ethnic landmarks, ethnicity. You can't say Oriental, Hispanic, etc., etc. Executive. So when you're drafting your marketing comments on that beautiful, McMansion in Granite Bay, make sure you don't talk about, executive home or anything like that. That's considered a fair housing violation. Exclusive, family, and I'll be honest with you, the exclusive one, I used to do it all the time. I talk about, a wonderful 4-bedroom, 3-bath home in exclusive Westlake. Why would anybody think that that would be a violation? But it is. Family, this is another big one. Can't say great for families. According to this, you're not supposed to reference family room, although we all do it. And I would imagine if it were challenged, I think the agent would probably win because MetroList actually includes that as an option on their choices. Female, gentleman's farm, grandma's house, handicap limitations, not suitable for. Integrated, male, man, marital status, membership approval, mentally handicapped, mentally ill, mentally retarded. So this isn't just marketing comments. This is in confidential remarks. This is anywhere within your listing that you're talking about. You can't name a religious school in your marketing comments. You can't even name, you couldn't say something like near St. Patrick's Church. You can't give the name of a church. I know some of these are a little silly, and it's kind of hard to see how they would fall into a discriminatory manner that would be considered unacceptable, but that's what HUD's come out with. Yeah.
So you can't say a walking distance to the place?
No, you don't want to say walking distance to anywhere because not all people walk. Some people are in wheelchairs, and are unable to walk. You can say close proximity to blah blah blah,
mileage or whatever.
Yeah, that's how I would get around that.
Bruce, back to the school thing. So I see things and they usually say close to good schools or great schools or whatever. Could you, if it's a public non-religious school, could you give the name like Bella Vista High School or something, or
yes,
just stay away from?
Yes, you can do that. You can say close proximity to ABC school. If it's a religious school or a church, you cannot give the name of it. And you never want to say walking distance, as we were just discussing. You never want to say walking distance to anything. Use the term close proximity to, or short distance from. Those are very, kind of objective terms that could mean a lot of different things. And if somebody happens to be wheelchair bound or, is otherwise disabled, that has no impact on them. Okay.
Absolutely.
So if there are, well, I think I'm going down a whole different path. If there's features in and about the home that you're advertising, can you list the positives without like saying, well, never mind. I'm going down.
Okay, so let me say what you could say. So, for example, if there's a walk-in shower, you can talk about that.
Okay.
You can't say why, you can't say walk-in shower for handicapped people. And I'm dumbing that down a little bit, but you would never say that anyway, but you can talk about the great aspect of having a walk-in shower. What you could not do though, and I had an example, I might even be in here. there was a phrase that an agent said to a client, and it was something along these lines. I found this house for you, or I eliminated this house for you because it's a 2-story home. And, with you being in a wheelchair, I didn't think you'd be interested in it. Well, that was actually a true fair housing violation. And the agent was trying to do the right thing by eliminating 2-story homes for somebody in a wheelchair. What the agent didn't realize was, and this is lack of communication with the client, the agent didn't realize that the guy wanted his family to occupy the upstairs and he was going to occupy the downstairs. So that ended up being an actual fair housing violation. And I should tell you, before we go any farther, you might be thinking, well, there's two different types of action that can be taken. One is the fair housing police come down on you and they can sanction you. If you get nailed with a fair housing violation, the Department of Real Estate probably will pull your license, right? But that issue aside, there are civil ramifications that the plaintiff or victim of your violation can go after you for. And you might ask yourself, what attorney is going to take a case like, I pulled houses for somebody in a wheelchair and I eliminated the 2-story homes because I was trying to help them out. What kind of attorney is going to take a case like that? Here's the deal. The way most of these fair housing laws have been structured in the interest of making legal assistance available to plaintiffs, the laws were structured to guarantee any attorney who successfully represents you and gets a ruling in your favor. The law requires that they be paid reasonable attorney fees by the defendant. So that's why it is very easy for these plaintiffs' attorneys to take on these cases, because they know if they have a decent case and they're going to win, they absolutely will get paid for it. So anyway, moving on. We talked about religion names. You can't say restricted. You can't say retired. Sex. We talked about that. Single or single person. You can say smoker in terms of establishing rules related to smoking on the premises. Let's see. Oh, it specifically talks about walking distance too. So as I said, you want to stay away from stuff like that. These ones out of the above are considered questionable words and phrases and could go either way depending on which of the fair housing police are looking at your case. Female roommate is questionable. Some will say, yeah, that might be okay. Some will say no. 55 and older is fine as long as it meets the HUD guidelines for an active adult or over 55 community. Male roommate, questionable. Neighborhood issues that you talk about are questionable. You can't say older persons, things like that. All right. Moving on.
Question about these lists.
Yeah.
Where are you finding these lists? And then is there any sort of notification on when there's updates to these lists?
These lists are pretty fixed right now, and you can find them in any Google that you do for fair housing phrases. You'll find them there. I'll work on preparing a list to get out onto the share drive, but most of them I think are kind of common sense. Some of them, the more iffy ones, are probably ones that maybe I should put out on a list, and I'll work on getting that done for you. Let's see here. California fair housing law. And California, as I said, is more strict than the federal government. California has been kind of a leader in fair housing. One of the reasons for that is because we have a really, really discriminatory history here in California. Most people don't realize that, but just in our area here, if you look at Rio Linda at one time was the home of the Grand Dragon or Grand Master, whatever they call it, of the KKK. Rush Limbaugh came from Rio Linda. That doesn't tell you anything. I don't know what will. But up until 1968, there were still conditions, covenants, and restrictions coming out for California communities that contained restrictive covenants that have since then been made illegal, and rightly so. I think I have another class where I talk about, I think it's either in my inspections or my disclosure class, and I show a copy of an old CC&R that was used. It was given out within the last couple of years to a client, but it still contained a restrictive covenant that said no persons other than white Caucasian may inhabit this premises. Even in San Francisco, which today is known as very liberal, I'd say very, very liberal. In San Francisco, you had, for those of you who are old enough to remember Willie Mays from the San Francisco Giants, in the early 60s, he bought a house in San Francisco, and he was one of the first to go into one of these restricted neighborhoods, and the KKK ended up burning a cross on his front lawn. So even in California, this stuff happens. And the Department of Real Estate, I think last year, July of 2022, made it effective that anytime you represent a buyer in a house that has discriminatory CC&Rs, there's a letter that you have to give the buyer that instructs them how they can have those CC&Rs corrected. So we're coming a long way. There's still a lot of those out there, even though they're illegal. They still get passed back and forth. But in California, the big kahuna in terms of helping to correct fair housing was the Unruh Civil Rights Act. And that was not just a fair housing law, it was a civil rights law. And that's the California law that prohibits discrimination, and you'll understand why this is important in a second. It prohibits discrimination by businesses, but the law doesn't define the word business. So basically, on its face, Unruh applies to all business establishments. And a business establishment is an enterprise that provides services, goods, or accommodations to the public. And that, just by definition, is not just limited to bars, shopping center, hotels, motels, restaurants, retail, blah, blah, blah. It also includes real estate brokerages. It includes homeowners associations. A homeowners association is an entity. As an entity, they're a business, so they have to comply with Unruh as well. That means if you're a real estate licensee that's engaged in any form of real estate activity, whether you're working as a real estate agent or you're working on property management, renting out residential units or commercial property, or whatever, you are governed by the Unruh Civil Rights Act. And under Unruh, remember I said that each of these laws have their own little protected classes. Under Unruh, they were or are sex, race, color, religion, ancestry, national origin, and then the most recent additions to that have been disability, medical condition, marital status, and sexual orientation. Now, a lot of the disability additions that have been done to the various civil rights and fair housing laws, they are a direct result of the Americans with Disabilities Act. That law, once passed, kind of trickled down to all the other ones, so which I think was a good thing. The other law that we want to talk about, sorry, I'm losing my voice a little bit. The other law that we want to talk about is the California Fair Employment and Housing Act. That comes out of the California Civil Code. If you want to look it up, it's section 12900. And that prohibits discrimination in employment and housing in the state of California. It generally picks up most of the federal anti-discrimination classes. It adds a few additional ones. And it's also known as the Rumsford, either Rumsford or Rumford Act.
Rumford Act.
What is it?
I think it's Rumford Act.
Rumford, okay. And that was the predecessor to the Fair Employment and Housing Act. And I think it was repealed in the late 80s. But the various protected classes under the Fair Employment and Housing Act, you've got age discrimination. That's, for people 40 and over. I remember years ago, clearly I'm over 40, but years ago, my wife, working at a company, and she was over 40, and there was a lot of talk about, they were having major layoffs on a regular basis. And I think the fact that she was over 40 kind of was one of the factors that saved her, because they didn't want to be faced with, laying off an over 40 professional woman when they were keeping younger people. So maybe that is some help. Other factors or other classes are ancestry, color, creed, pregnancy. You can't deny pregnancy and disability leave. Various disabilities, mental, physical, including HIV and AIDS, genetic information, gender identity, marital status, medical conditions, and military, whether you're a veteran or not, national origin, race, religion, sex, and sexual orientation. So you can see, kind of based on what I've said so far, depending on the law and the classes named in that law, there is virtually no person that I can think of that is exempt from being discriminated against if you take certain actions. So with that in mind, don't even worry about the actual laws, just worry about not taking discriminatory action by, based on your acts in who you're showing property to, how you're showing it, how you're advertising, and things like that. Let's see. Federal Employment and Housing Act makes, as I said, makes housing discrimination illegal. Under California law, persons who rent, lease, or buy a home are protected based on their age, ancestry, citizenship, color, blah, 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 all that stuff that we talked about. They've added to that sex, but they have not modified that yet to something other than what sex was assigned at birth. Sexual orientation is protected. Let's see. All right, let's move on down. What are the penalties for a fair housing violation in California? Well, they start with a civil penalty of $50,000 for the first violation, or $100,000 for subsequent violations. And as I said, you're going to end up having to pay attorney's fees and costs. And the one thing that you have to also think about is you will lose your real estate license, and you'll have difficulty getting any other state type of license other than a driver's license. Now, as far as the DRE goes, how do you get in trouble? You refuse to sell, rent, or finance real property because of racial or other characteristics. If you refuse to show property or volunteer information about a property for racial or other discriminatory reasons, you can refuse to show property to a handicapped person only when there are hazardous conditions or architectural barriers that would hinder the person's access. So that's about the only reason you would have for that, or the only way out you would have for that. Discrimination in the negotiation, sale, or services related to loans or installment sales contracts are a violation. Offering discriminatory terms in the sale, rental, or lease of real property. You may offer different terms for properties containing special facilities for the physically handicapped, though. Conducting any discriminatory business practices prohibited. That can include referring minorities to other brokers or to specific salespeople. Use of codes or other means of identifying minority prospects, or processing applications like to rent or to borrow differently. Making false statements as to the availability of property isn't permitted. Processing someone's application more slowly than that of other persons in an attempt to hinder or delay the rental or financing of the property. Refusing to cooperate with another licensee because of the racial or discriminatory characteristic of the licensee or the licensee's customer is prohibited. Discouraging the purchase or rental of property because the person is a different race or other discriminatory characteristic than the majority of the people residing in the area. And a lot of these, to me, they seem pretty common sense, but apparently they're not, because they do keep coming up. Placing or displaying selective advertisements to attract only specified groups, except affirmative marketing campaigns to attract racial or other groups that might not otherwise be attracted to a particular area. Instructing or encouraging others to discriminate against people. Using rules which limit a person's opportunity to benefit from the multiple listing service. Participating in any activity that would promote panic selling. I want to give you a real life true example of this that I know about firsthand. And this is called blockbusting also, another common term you might have heard. So the KW Sac Metro office is in an area called North Natomas. And there's a street in North Natomas, Del Paso Road. And if you drive down Del Paso Road, there is a community called Natomas Park. It's 5,270 homes in this community. And the outer boundary that runs perpendicular to Del Paso Road of Natomas Park has a row of houses that form the edge of Natomas Park. And that row of houses, right over the back fence, there's a big vacant field that's about a quarter mile wide and about a mile long. And that section of the mile long goes from Del Paso Road to Elkhorn, sitting right in back of this row of houses in Natomas Park. Well, in the mid-2000s, there was a husband and wife real estate team, and the husband, who ironically is Black, was knocking on doors of this home, and his spiel to the homeowners went something like this. Mr. or Mrs. Homeowner, my name is so-and-so. I'm a real estate agent with such and such realty. The reason I'm knocking on your door and bothering you today is because I feel it's very important that you understand that the city has approved low-income apartment buildings to be built right behind your home in that big vacant field. Now, you probably should realize that once those low-income apartment buildings are constructed, your property value is going to tank. So if you were ever interested in selling your house, now would be the time to get it on the market before they break ground on those apartments. Now, the truth of the matter is, and it really is irrelevant whether what he said was true or not, it would still be a fair housing violation because he's promoting panic selling. The sad thing here is it wasn't even true. To this day, 18 years later, there is still nothing that has been constructed there. And I don't know of any plans to put anything there. But even if it were true at that time, what he did was blockbusting. He was trying to induce panic selling of real property. Now, you might ask, why do I know about this? Well, I know about it because I listed one of those homes and sold it. And when I showed up for my listing appointment, my client handed me this agent's business card and told me this story about what he told her. So I have it on, pretty good authority. This is what the agent did. This agent, ironically, was an African American, or is an African American, and he did later get his license suspended, although not for that reason. So this kind of stuff does happen. Now, I want to bring up, I told you earlier, I was going to talk about steering and how to avoid getting into trouble, because that's the one where you can get into trouble predominantly by accident. It's not because you're intending to do something discriminatory. So this would be a classic case of steering. You guys are out there, you're pounding the pavement, trying to drum up business, maybe running some ads, maybe running some online stuff, and a buyer contacts you and says, yeah, Amy, it's great to talk to you. I got your name from so-and-so. Me and my family currently we're in a rental in San Francisco where I work. But now we can work from home and they're never going to go back to the office. And we can't afford a house in San Francisco. So we were thinking we'd buy a house in Sacramento and I can work out of home and it's a lot cheaper and we can afford to live there. And you say, great. And I should mention, your client happens to be, let's just say they're a minority, an African-American maybe. And you say to them, gee, Mr. Smith, where would your family like to live in Sacramento? I can set up some searches and they tell you, well, we're not sure. We don't know the area. And so you move on and you're finding out their requirements, how many bedrooms they need, how many bathrooms they need. Are they okay with 2-story homes? Do they want single story? Do they mind an HOA, or are they dead set against an HOA? Who are they pre-approved through? How much are they pre-approved for? All that good stuff that you would normally find out in your fact-finding meeting. And then you come back to the area and they still have no idea where in Sacramento they want to live. So you say, okay, I'll send you some leads. And you go through and you look in the MLS and everything for the 3-bedroom, 2-bath, X number of square feet home that they want with an HOA, and you find 300 listings. Well, it's a little bit of an overload. So you make an assumption, and I'm obviously, Amy, I'm not going to suggest that you're going to make this assumption, but where an agent gets into trouble is the agent makes an assumption. Well, gee, I think the person is African American. Let me focus my search in areas where I think African American people want to live, so they can be by people that they feel comfortable with. And That's how you get into trouble. The way to get around this, the better way to get around this is you say to your client, look, I've come up with 350 listings all over that fit your criteria. And I know you don't know Sacramento yet, but let me do this. I'm going to put you on a distribution, and you're going to get tons and tons of these email links that you can go through. What I'd like you to do is look through some of them, pick a few of them, and maybe come out on a Saturday, come out on a Sunday, and you can tour and take a look at some of these homes, see if you like what you see around the homes. And then if you can isolate down a few, I can try to set up searches in those areas that you think you like, that are close to the freeways you want to be near, that are close to schools that you want to get your kids into. If you can pin that down for me a little bit, then I can customize your search so that all you're going to see are homes in those particular areas. And that way, you're helping them to help you make a decision where they want to look. By making a decision on your own is where you create the problem for yourself. Now, you don't intend to make a discriminatory, to do something discriminatory. You're trying to help them. But in trying to help them and making assumptions, that's how you can get yourself into trouble. The other thing that comes up is people will say to you, gee, I really like this house. The wife and I were talking about maybe having you put an offer in for us, but we have 2 kids in school. What are the schools like around here? What you'd want to say, the appropriate response to that is, you don't know what the schools are like. And in fact, you generally don't research the quality of schools, because what's good to me may not be good to you. But what you can do is you can point them to various websites. You can tell them to Google, school ratings in such and such area. And they'll be able to find online stats, scores from the students' testings, things like that. The other one that'll come up is they'll say to you, gee, how safe is this neighborhood? Well, that's another one of those questions that you never, ever want to give a definitive answer to. Why? Because it's subjective. What's safe to you? This is my standard answer when I was asked that by a buyer. I would say, well, number one, because of fair housing laws, I can't make subjective statements about the quality of an area. That can get me into trouble. But also, you have to realize what's safe to me may not be safe to you. I'm an old Marine. I'm an ex-cop. I carry a firearm with me. So what's safe to me is totally different than what's going to be safe to you. And so, you have to make your own decision as to that. What I'd suggest you do, though, is drive around the area, different times of the day, on different days of the week. See what you think about the area. Maybe go online, check crime statistics. Every city has crime statistics. Every county has them, and you can probably even peg them down by zip code. So check that stuff out, and then you can make your own decision. It's just like the Megan's Law database. That's open to everyone to look at. You can find out how many high-risk sex offenders live within X distance around your property. And again, that's something you would never want to look up for them. They can look that up for themselves. All right. Any questions on that so far?
That was great.
No? Okay. We've already spoken a little bit about stuff that you don't want to put into advertising. Some of the common ones I think have already been touched on about, you never want to put in the marketing comments walking distance to X, anything like that. You don't want to talk about family neighborhoods, family cul-de-sac, anything like that. So, just stay away from that type of thing. Let's see.
Bruce, I do have a question. I
Yeah.
seem to remember in one of the courses to get licensed, there was something about like if an individual renting a property is like renting a room in their personal home, they are able to give some specifics on who they want to have the room rented to, like they want it to be a woman if it's a woman. Is that still the case, or am I just, my memory's like,
That is still the case. So
Okay.
if it's a single family residence and a homeowner is living in the house, they can be specific as to wanting if she's a woman, she can ask for a woman.
okay,
But in terms of your real estate career, since we don't do property management here, that's never going to come up with you. And if you ever have a client that wants you to give them property management advice, tell them to talk to a property manager.
yes, it was my mom who was asking, so I
Oh,
was
okay,
like,
all
yeah,
right.
can't get out of
Um,
that.
Yeah. The reason, if you're curious, the reason we don't do property management here at Keller Williams is because the Department of Real Estate puts very, very, very stringent requirements on brokers of property management companies in terms of how they maintain their trust logs and their trust bank accounts. And I mean, it involves dual accounting, one for the total of all properties managed versus a single one for each property managed, and how they have to be balanced on, monthly. And point of fact is, more brokers get their licenses revoked for discrepancies in trust fund logs than for any other reason. So we make it easy here. We don't do it. Now, if you're a broker here at KW, if you're an actual licensed broker associate here, and you want to have a separate corporation that's licensed as a property manager, you are welcome to do that, but it would be under your own license. All righty, I want to go into just a quick summary of the antitrust laws. Antitrust, for those of you who maybe remember from your high school years, this all comes from a federal law known as the Sherman Antitrust Bill. And I was in high school a very, very long time ago. And I'll confess that in law school, they didn't go over the origination of the antitrust laws. But I will tell you that my recollection is that it came about from trying to break up J.D. Rockefeller and the whole Standard Oil thing. They don't want anti-competitive activity that kills competition. And so there are a few key things that antitrust goes after. And this is federal law, and the fines are severe, as you'll find out in a moment. But price fixing is a per se antitrust violation. What that means is whenever you have a law followed by per se, that means that the government's case is such that it is price fixing unless the defendant proves it wasn't. So it's not like a normal criminal type of action where the prosecution has to prove that you're guilty. Here, you're presumed to be guilty and you have to prove you're innocent. So one of the types of price fixing is market or customer allocation. So what that means is you have a broker. Let's just give an example. Brokers agree to divide territories. So if there's two major brokerage firms in a city and it's divided by a river, it would be a violation if they decided to divide between them who's going to take properties north of the river versus who's going to take properties south of the river. Any kind of an agreement like that would quell competition, which would therefore be antitrust. Another big one is bid rigging. That is also per se antitrust. I'll give you another real life example of that. This one is near and dear to my heart because this is My wife was involved with a company. My wife and I met doing foreclosures. So years and years and years ago, before I got into real estate sales, I was actually doing processing foreclosures in California. And my wife worked for my girlfriend, or before I met her as my girlfriend, she worked as a foreclosure trustee. So the stuff the overflow that my company couldn't handle, we would farm it out to her company. She was based out of San Diego, and in San Diego, there was a group of people, and I think their moniker, they were known as the 20 gang of thieves, or the gang of 20 thieves. And the way a foreclosure works in California is a bank will file a notice of default against the mortgagor. 3 months later, the bank files a notice of trustee sale, and then within a couple of weeks after that, they have an auction at the courthouse steps, and somebody can bid. They have to bid cash or cashier's check. The highest bid gets the property. That's the basics, very basics of a foreclosure. Well, there was this group of investors down in San Diego, and you know which foreclosed properties are going to be available for bid ahead of time, because you find out when they file the notice of trustee sales. Those are filed documents with the county, and they can be seen by anyone. So these guys would show up at the courthouse steps, and they have a plan that they put together in advance of those sales. And they would say, Joey, you're going to get the property on X Street. Steve, you're going to get the property on Y Street. Don, you're going to get the property on, T Street. And each of these properties would come up for bid, and these guys would start bidding on them. And if anybody outside of their little group of 20 tried to bid on a property, then the gang of 20 would bid up the sale so high that these people would have to drop out. And then they would calculate how much over their targeted number they ended up having to bid to get the property. And all of the 20 members would chip in to lower that loss for any one single member. And so by doing so, they quelled competition, because everybody else knew that they were never going to get one of these properties. And so the Department of Justice stepped in, and they eventually made a bunch of arrests and put an end to this in San Diego. But it actually came up again because in recent years, the DOJ got 40 guilty pleas in a bid rigging scheme in Northern California. So this kind of stuff still happens. The example I gave to you happened almost 40 years ago, but it still happens to this day. So that is antitrust. Bid rigging is antitrust. Here's the one, this last one that I'm going to give you. And this is the one that affects real estate agents most. And this is the way that real estate agents can get into trouble. If you, let's just say Amy and Reza,
Yes.
if you two are sitting in a car touring homes that are having, open houses, and you're looking at them because you both might have interested clients, and you guys are going around together looking at these houses. And if Amy says to Reza, this next one we're looking at, this is one of Bruce Hammer's listings, and he's only offering 1.5% in the MLS. I am never going to show any of his listings. If you guys get into a conversation about that, 2 or more people conspiring to commit price fixing by not showing somebody's property, that's an antitrust violation. It's also conspiracy. So you get 2 for 1. That's kind of a, you think, oh, that's a silly example. I can tell you 15 years ago, we used to do a thing in Natomas here every Thursday morning. We'd have a quick meeting with the realtors. Then we would, carpool. We'd all jump into somebody's vehicle and we would go look at all the new homes for sale. I actually sat in the back seat of a car while two agents in the front were having that very conversation. And I informed them that they better knock it off because that is an antitrust violation. They probably thought, who is he, Mr. Goody Two Shoes? But the fact of the matter is, you don't want to be involved in those types of conversations. And not to mention the fact that it's wrong, it's anti-competitive, and there's plenty of business to go around, without playing those kind of games. The penalties for an antitrust violation and conviction for the average corporation, the penalties can put you out of business because they can go up to $100 million. For an individual, the penalty is $1 million plus 10 years in prison. It's actually a crime. So you never want to get into a conversation about commissions with anyone. We as an office, we have minimums for the office on listing and buy sides, but that's not considered antitrust because we're setting a policy for an office. But when commissions are negotiable, as you know from your licensing study and your licensing exam, completely negotiable between buyer and seller and whatnot. So you never ever want to have a discussion about how much somebody is paying on commission, whether you want to do business with them at that rate. You can make a conscious decision in your own mind, but never voice that decision with any other person, because then you get into an antitrust conversation. All right. I think that is it for today. Any last questions I might be able to answer for you? No?
Nope.
I
Thank you.
have one. I do, Bruce, sorry.
Oh, no
It's
worries.
fine.
How can I
So
help?
I think I need a little bit of clarification about the whole using the term senior complex or senior living 55 plus. Like you said that it has to meet certain criteria, or
Yeah. So here, let me hang on one second. There is. Bear with me here. I had it, I guess I don't. All right, so the reason that it's okay if it's 55 or older is because the Department of Housing and Urban Development has set criteria, and they have two different ways of measuring that criteria for whether it is okay to advertise senior housing. And senior housing is also synonymous with active adults. Sometimes they're not active, but they're still senior. But the criteria is they have to have X percentage of the homes marketed only to 55 or older. And both of those types of criteria that they have will qualify as either senior housing or active adult over 55 housing. As long as they pass muster on those, then you're okay advertising it as senior/active adult housing or senior over 55 housing. The example would be a place over here near my office or near our office here in North Natomas. They have Heritage Park. One member, and that's part of the other criteria, one member in the household has to be over 55. Other than that, there's a lot of leeway in terms of who can occupy the place, subject to limitations on how many the county allows per bedroom and whatnot. As long as one person meets the criteria of 55 and older, they can advertise it as senior housing, 55 and older, active adult, any of those criteria. But you're going to know that the property is that because that's how they're going to be advertising it.
Right, okay. So it doesn't have anything to do with what features they have in the park or in the homes as far
No.
as
Nope.
railings, it's just age, totally age.
Just age. And, and things like, handles in showers and things like that. MetroList allows you to check that stuff off in their system.
Okay.
Yeah.
And so, I mean, obviously this is what it is, but like, why is that okay? Is it just a courtesy for us old folks that it's like, you know what, you deserve to have a place without a bunch of raucous kids? Or why is that age not considered a discrimination or anything like that? Or
Because there have been court cases that, for whatever reason, the courts have ruled that that's not a violation. It sounds like a trite way to answer it, but that's,
so I get it. It is what it is. It's just,
yeah. I mean, a lot of these laws that we deal with today are purely as a result of case law, either on the federal level or on the state level. A lot of them, of course, are statutory. A lot of them are constitutional, but a lot of them are also just case law. And,
okay.
And I mean, if you think about it though, I think as somebody that is in that age group now and, winding down the years towards retirement, I think I like the idea of living in a place where there's not a bunch of, kids running up and down the streets and leaving their basketball hoops out 24/7 and bouncing their balls 24/7 and all that good stuff. So, I think there's good reason for it.
Okay, thanks. That was helpful.
Okay. Anything else?
No, thank you. That was great.
All righty. Next Tuesday is 4th of July, I believe.
Ooh.
We won't be having class next Tuesday, but we will pick up the Tuesday after that.
Thank you.
Thank you, Bruce.
You're welcome. You guys have a great afternoon.
Thank
All
you.
right, have a good 4th.
You too. Bye-bye.